Aloha, Keeaumoku Kapu from Lahaina once again. I'm going to stem off of the affidavit once more. That the affidavit, once you put out this and once you get it notarized through a regular public notary, mine went to the bank, and that finalizes your affidavit. You want to pursue it another step forward, you file it in the State of Hawaii Bureau of Conveyance. So submitting this in a Bureau of Conveyance, they'll look at it. There's a cost to it. I think $40-something if it's within like 20-something pages. There's a reminder out there that if people are filing affidavits, that if you go 51 pages, they're going to charge you double. So I encourage everybody to stay under 50 pages. Don't go 51. Once they look at your document and everything is clear, clean cut, you got to make sure that the spaces is all in the right place. Then they'll stamp it and they'll give you a docket number. Once they give you the docket number, then you somebody, you're alive. You're part of the kupuna that was awarded property during the time of the Mahele back in 1843, 1848. So this document shows that you have possibly an undivided interest of lands that was awarded during the time of the Mahele or during the time of the Crown, and this is your pursuit to redemption. And once the document is formed and finished, this is your title to go home. And this is all you need. It's to challenge the validity of somebody who claims to own 100% interest of the property that it was awarded to your kupuna. So it's to literally go in and challenge the validity through the palapala. So once it's stamped, this is your title to go home, and this is your title to challenge. One of the things that I encourage a lot of people to is once you get this done, then the next step would be is to file, put together your sign. So the sign clearly shows, and I'm using Likua as an example to this, and it's separate from my affidavit for clarity. But Likua has two apanas, apana 1 and apana 2. And it says private property, no trespassing, Land Commission Award 9583, Royal Patent 2746, heirs to Likua, subject heir to KHPA. So I'm bringing up the governing body at that time, the constitutional monarchy on the Ko Hawaii Paia Aina. Yeah. What I also put on the sign is this word, Wakoe ke Kuleana Lands, and that literally means reserving the rights of the native tenant. Okay, Wakoe ke Kuleana Lands. So a lot of laws that was implemented for Native Hawaiians, especially Kuleana that had lands, a lot of things they talk about in the so-called book, Wakoe ke Kuleana, is all those little rights that you have. So Wakoe ke Kuleana Lands, reserving the rights of native tenants, integrating Kuleana rights and land trust priorities in Hawaii. This was done by Jocelyn Borovoy, which came from Harvard and all these colleges in the mainland, on researching native tenants rights, Kuleana rights, all these kinds of rights out there, and just kind of condensing it down as pertaining to where our rights are when we start pursuing our interest of going home. Okay, so it says rights of reasonable access, early access cases after the enacted of Hawaii, revised statutes, section 7-1. So 7-1 is Native Hawaiians' rights to gather, Mauka and Makai, that those rights are not to be obstructed for Native Hawaiians who want to go and gather la'ola pa'ao for medicine, even as far as going to the Mauka areas and gathering timber for building their houses. They have the right to do that. Vehicular access rights, rights of agricultural uses, cultivation of crops, grazing, gathering rights in the Ahupua, rights of single-family dwelling, You know, all these kinds of things. The pursuit of going home, yeah, it doesn't necessarily mean that this is all you need. The research and a lot of things that you're going to have to do after is understanding where you stand and what protects your rights as on Kuleana, and that the state as well as the county through 343 and the state through the constitutional law, Article 12, Section 7, and you have the Hawaii Revised Statute 7-1, Native Tenant Gathering Rights, 1-1, HRS 1-1, that the department or agency such as DLNA has to make sure that Native Hawaiian rights are not being infringed upon. All those things are all in here. You would have to understand it and know how to MacGyver this thing when you start pursuing the property on where you want to go. Now, if all of a sudden there's an obstruction of the gate, then there might be some troubling a little bit. But to find that you have an ingress-egress right, so all Mauka and Makai is Uokoike Kuleana Nakanaka. Once you understand the laws of the native tenants, then all these kinds of things is really simple, yeah, for your pursuit in going home. This is kind of a flag to say that this sign is going exactly on the property of what you're searching for or what you're seeking for. This answers for itself that you have ultimate rights that fall upon Kuleanas just by placing the sign. Once the sign is up, then you even more challenging the validity of their title physically, because you're now on the property physically, and this is the pala that you need to follow up just in case they want to file something against you claiming that they own an interest, that this would be the pala that you would be sitting in submitting in as an argument to your case. Okay, once everything is done, once you post your sign on top, I encourage a lot of people, don't just put a sign, you got a noho on the area, which means time for go home. Get on the area and where you're going to post a sign, knowing that you have the backing of your kupuna by way of an affidavit filed in the Bureau of Conveyance, that anybody that is lawfully binding can also go into the Bureau of Conveyance and pull the document, but they would have to pay for it. Once they pull a document, and if they want to challenge, the first thing that a lot of people that want to challenge is to try to figure out where is the break in title. Now, when they start going through your information to figure out where is the break in title, there is no break in relationship to this, because it shows certified documents from you all the way to the mahele and all the way to the land commission award that was awarded to the kupuna. The person that is occupying the lands would have to show without a reason of a doubt that there is a change in title, yeah, and where somebody in the family would transfer the interest over, and that would validate them. What we've seen most times in the past is title is being acquired in Hawaii through ways of a warranty title deed or a quitclaim, and all these boil down to title insurance. Now, if people claiming that they had the property that was signed over legally, then why they gotta buy title and insurance? Why all of a sudden they have to pursue saying that they're gonna pay, or the researcher like Title Guarantee is gonna tell the person pursuing the property, saying that I'll do a title search on this, and it'll cost you $1,000, yeah, title warranty to show that they have an interest. Once they come up with something like this, now they got to do their homework, not up to the title guarantee, but they would have to go all the way from the time of the title that was created to find out where the break and chain is. And yeah, that would be the process to finding redemption for everyone pursuing to find out whether or not their Kuleana lands are still intact.